Yes, okay, here we go, guys.
All right, welcome back, everyone. For those of you who did not see the midday presentation, I strongly encourage you to look at a lovely presentation that is available through the links in the chat. Our next topic is medical, ethical, and legal consideration in end-of-life care. Guiding any person through the last phases of life and making decisions about end-of-life care is challenging and emotional for patients, families, direct care staff, and medical providers. Additional challenges in navigating the Opwd framework for decision-making makes an already difficult decision that much more complicated. I'm proud to introduce the three speakers who will discuss the process and challenges of end-of-life care in people with intellectual and developmental disabilities. Our first two speakers represent the Office of Mental Hygiene Legal Service, or MHLS. This office provides legal representation for individuals who receive or are in need of services for mental illness or developmental disabilities, including individuals in psychiatric hospitals, community residences, and other facilities serving the disabled. MHLS also frequently serves as appointed counsel or court evaluator in adult guardianship matters as counsel or guardian ad litem in guardianships. Julie Friedman has been an attorney with the Albany Regional Office of Mental Hygiene Legal Service, a division of the New York State Appellate Division, serving as the managing attorney for the Albany Regional Office and Kingston Office since 2020. Ms. Friedman is a frequent speaker on legal issues related to the work of MHLS and has been invited to speak by state and local bar associations, hospitals, agencies, and organizations providing services to individuals with disabilities. Ms. Friedman is a graduate of Cornell Law School and Cornell's University's School of Industrial and Labor Relations. Sheila Shea, Esquire, is the director of MHLS. She has served as its director since 2007. She is a graduate of the University of Vermont and Albany Law School of Union University. Ms. Shea is a member of the New York State Bar Association, its Elder Law section, and serves as the NYSBA Committee on Disability Rights. Ms. Shea is the recipient of the 2013 Hodgins Jacobs Law Award presented by the New York State ARC for demonstrating outstanding commitment and dedication to improving the lives of people who have intellectual and developmental disabilities, and the 2014 Cerebral Palsy Associations of New York Public Service Award. Our third speaker is Dr. George Jocas, who is a physician specializing in the care of patients with serious illness. He sees patients at Ellis Hospital and is a member of the Ellis Medicine Ethics Committee. An internal medicine physician for 25 years, he now focuses on palliative medicine. Dr. Jocas developed the palliative care program of Community Hospice, St. Peter's Health Partners, and Ellis Medicine. In addition to his clinical responsibilities, he remains active in the education of clinicians and the community on palliative medicine and end-of-life care. He is board certified in internal medicine and hospice and palliative medicine, with additional training in geriatric medicine. He received his undergraduate degree from Tufts University, his medical degree from George Washington University, and completed internal medicine residency at Albany Medical Center. Welcome to our distinguished speakers. I will turn it over to you.
Good afternoon, everyone. I'm Sheila. Shea, I'm going to begin our program today. Our panel identified 3 learning objectives for today, and they are that we hope to help you understand the legal framework underlying decisions to withhold or withdraw treatment at the end of life. And by legal framework, I mean the statute that governs this process, which is Surrogate Court Procedure Act 1750B. And so you will hear Julie and I speak about this statute through much of our remarks today. We will defer to our doctor panelists, but objective number 2 really is to describe the elements of benefit, efficacy, and effectiveness as applied to decisions at the end of life. And then our final objective is to help you identify resources that can guide clinicians through the process, which we mean the process is the statutory process, Surrogate Court Procedure Act 1750B. As we thought about, our panel thought about key principles or takeaways for this program, we identified 2, and I just like to separate them. One pertains to patients who lack capacity to make their own healthcare decisions, and the second objective pertains to patients who possess capacity. So for those patients who lack capacity to make their own medical decisions, a key principle for today is that, in our opinion, the statutory framework, Surrogate Court Procedure Act 1750B, has achieved what were the legislative objectives, and that those were really twofold: to promote efficacious treatment where treatment would be beneficial to the patient, but also to promote dignity at the end of life. So those really a dual purpose there when we think about 1750B. For patients who have capacity, we like to think upstream as much as possible and engage in advanced planning, because a person with a developmental disability can engage in that planning. So part of our program will be focused on healthcare proxies and advanced care planning for clients who have capacity. When we talk about 1750B, the statutory framework, Julie and I, in a variety of contexts, are often asked, why do we have a separate statute governing healthcare decision-making for people with developmental disabilities? And it's sometimes good to try to put this in some historical context. And historically, people with developmental disabilities were subjected to terrible conditions, such as the Willowbrook State School. People with developmental disabilities were subject to unethical human experimentation, and were victims of the eugenics movement. And there were state statutes that authorized sterilization, for example, for people with who were thought to be mentally defective. When I think about historical context as well, the second point I really like to emphasize came to me from a discussion I had with the former chief medical officer at the OD Heck Developmental Center. She was a lovely woman who told me when I was starting my practice at MHLS that from her perspective, patients with developmental disabilities were often undertreated due to a bias that people with developmental disabilities have a diminished quality of life, or our clients were overtreated because of the strictures of our common law, which we can discuss later. But that's the historical context which led the legislature to craft a remedy. And the statute that we're going to talk about was codified in 2002, I believe, effective 2003. And it predated the more general statute that you may be familiar with, which is the Family Healthcare Decisions Act, which was promulgated in 2010. The other thing we wanted to talk about, just to kind of set the foundation for our remarks today, are frequent misconceptions. And we've identified 4 that we think are critical. But certainly, we like to disabuse the people we talk to in audiences or when we're engaging in education and training, disabuse the notion that people with developmental disabilities lack capacity for all purposes, or that this population require guardians, or that they're quote unquote wards of the state, which is an antiquated concept and really doesn't have any meaning. But these are persistent stereotypes, I think, that people with developmental disabilities are not able to make their own decisions when many can. For those of our clients who have guardians, we also want to say that guardianship may be plenary, and that is that the guardian may have expansive powers, but all guardianships in New York should be administered in a way that allow people who are subject to the guardianship regime to exercise their autonomy when they can. That's a legislative pronouncement, and that's really how guardianships should be administered in practice. The final thing I wanted to point out, and this was a personal misconception that I wanted to add to the list. I have read so many medical records in my time as an attorney that contain a narrative about the patient, and so many times that narrative will say about a person with a developmental disability that the person's unfortunate, which seemed to me that the narrative is saying that this person's burdened by their life circumstance. And I'm not sure what the origin of that is, but again, I'd like to get away from that notion that our clients are unfortunate. They live full, meaningful lives, and their autonomy should be respected. So I'm going to ask Julie to continue.
Thank you. Good morning, everybody, or good afternoon, everybody. That is a good segue for talking about what people with capacity can do. So any individual who has capacity, whether there's someone with an intellectual disability or anybody else, anyone else who has capacity is able to make their own healthcare decisions. And along with that power, anyone who has capacity can execute a healthcare proxy. The standard is that they really have to understand that they're delegating to another person, and that other person is referred to as an agent, the authority to make healthcare decisions for the principal. So the person who gives somebody else the power is the principal, and the person who can act on that power is the agent. So I think it's important to start for an example. You can have a situation where someone who has a type of disability may not have the capacity, may not have the ability to make a complicated decision, such as, for example, deciding between different options for a complicated cancer diagnosis. But they may have the ability to say, I trust my sister, and I would like my sister to make healthcare decisions for me. So I'm going to execute this healthcare proxy, and so that she can make decisions for me. That is a situation that does come up with our clients. And in that case, as long as the person has capacity to execute the healthcare proxy, but lacks the capacity to make a specific decision, then the agent can act under the healthcare proxy. And because I'm a lawyer, I have to say that there are some exceptions to that, and we're going to get into that a little bit later when we actually talk about end-of-life decision making. So a healthcare proxy doesn't normally go into effect, well, cannot go into effect unless the individual lacks capacity either for a specific decision, like the example I just made, or temporarily or permanently. So for example, if I was going to the hospital for a medical procedure, I would make sure that my current healthcare proxy appoints a family member to make decisions for me in case I am temporarily unable to make a decision, either, for example, let's say a medically induced coma, or I become on a intubator on a ventilator and cannot communicate my wishes, or let's say someone has an accident, they have a stroke and they're temporarily incapacitated. Their healthcare agent would be able to make decisions for them. Permanent incapacity might occur at the end of someone's life. Perhaps they have dementia, perhaps they've had a catastrophic stroke or a very serious illness or injury. And so they used to have capacity, they used to make their own decisions. They proactively executed a healthcare proxy. Now it has been determined they can no longer make their own medical decisions. And so they have someone waiting in the wings, hopefully someone who they have discussed with some of their beliefs, cares, concerns, positions about medical decision making. So in general, a healthcare proxy has to have 2 witnesses and it has to be in writing. And that's the case regardless of who is executing the healthcare proxy. And a healthcare proxy has to be executed by the individual who is giving their decision making to someone else. So for example, we get calls from someone who has a child who may have a severe intellectual disability and they say, I want to be their healthcare proxy. Well, you can only be someone's healthcare proxy if they have given you that power. So again, start with they have to have the ability to give you that power. And the person who will be the agent cannot be the witness. So I alluded to this before, the agent's authority does not begin until the principal is deemed incapacitated by an attending physician. An agent can make any healthcare decision that the principal would be able to make. And decisions by the agent must be made in accordance with the principal's wishes, including religious and moral beliefs, if known. If not known, then it would be in accordance with what would be in their best interest. And that's in the public health law. So for example, if my sister is my healthcare agent, she and I may have very different views about end-of-life care. We may have very different views about religious beliefs regarding artificial nutrition, hydration. But if you're a healthcare proxy for someone, if you're someone's agent, you have to make the decisions based on what you know about them, not on what you think, not on what our parents may have wanted for us, but based on the individual for whom you're making decisions. There is a little bit of a wrinkle in the public health law. An agent cannot make decisions to withdraw or withhold artificial nutrition and hydration unless the agent is aware of the principal's preferences in that regard, or the principal's preferences can be ascertained with reasonable diligence. And this really becomes a fact issue that can come up, especially at the end of life. And this is another reason why for everybody, if they're doing a healthcare proxy, it's important to have these conversations about what you would expect and what you would want at the end of life. So this slide has a lot of information on it, and I don't want to take up too much time going through all the details. But the reason why I put it up there is that it's very important to know for this audience that for someone who is residing in a facility operated or certified by Opwd, as well as a facility operator or certified by the Office of Mental Health, they're including a unit of a private hospital that serves as a psychiatric unit. There are special witnessing requirements. And the purpose of having special witnessing requirements is so that we don't either have people who are being either pressured into signing something they don't understand or perhaps taken advantage of, but also so the witness has some understanding of capacity issues for the population that they're dealing with. So for example, if you are asked to witness a healthcare proxy for someone who is in the Opwd system, there has to be an appropriate assessment of the person's capacity to execute the document. And so you see, we have a whole list of people who can serve as witnesses. Also, in addition, one of the witnesses must not be affiliated with the residential facility. Often, one of the witnesses is one of the physicians is listed below in the 4 items at the bottom. And then perhaps the other individual is someone who's at the person's residential facility, someone who they might be familiar with. Healthcare proxies, unlike a lot of healthcare documents, healthcare proxies, you can use a photocopy, you don't have to have the original. And I always recommend to people, including family members of mine who do healthcare proxies, that you have a lot of copies and you provide them to your physician's office, to the agent, and also to other healthcare providers that you may have. So we're talking about people who have capacity either to make their own decisions or to delegate decision making to someone else, which is what a healthcare proxy is for. But what if that's not the case? What if you have someone who doesn't have capacity? So if there's an individual who is intellectually or developmentally disabled, who previously had capacity and they executed a healthcare proxy, the agent can make decisions with them, for them, excuse me, within the parameters of power that's given to them and underneath the various laws that apply to end-of-life decision-making and other types of decision-making. But what if there is no agent? Just today, I received, oops, I gotta go back. Oh. So just today, we received some materials for end-of-life decision-making, and the person had a healthcare proxy, but their healthcare proxy, who I believe was an older sister, is now deceased. So for all intents and purposes, that person does not have a healthcare agent anymore. The individual that they had is no longer available because they passed away. Sometimes there's a healthcare agent who just simply doesn't want to be involved, doesn't want to make decisions, or perhaps is unreachable. The other situation, which I think is much more common with our mutual clients, is the individual never had the capacity to appoint an agent. So if they never had the capacity to appoint an agent, and that's the most common situation that we are in, and now we get to the actual legal framework of what we would do in that instance, really focusing on what we would do in end-of-life care, since that's really the main issue that we're concerned with here today. So I'm going to turn it back to Sheila, and she's going to explain the legal framework.
And before I do that, I wanted to explain that our panel is interdisciplinary. So part of what Julie and I are doing is just setting the foundation for legal principles. And then we have our physician panelists, and that will enable, we hope, for you in the audience to see the interplay between the law and the medicine. And we'll do that in the form of a case study as we get further down into our presentation. The other thing I wanted to say, I'm going to run through this legal process, but you've also been provided written materials, and included in those written materials is an article that's published by the New York State Bar Association. And that article provides some historical context for the enactment of 1750B, and then a description, a narrative of the process. So you'll have these slides and you'll have the written material. But again, the legal framework that we're talking about is a statute. It's Surrogate's Court Procedure Act 1750B. It's a healthcare decision-making statute embedded in the Surrogate's Court Procedure Act. And people ask, why? Why do we have a healthcare decision-making statute embedded in the Surrogate's Court Procedure Act? And that's only because the legislature placed the decision-making, healthcare decision-making provisions within the Article 17A guardianship statute, which is part of the Surrogate's Court Procedure Act. So that's where you find it. The law was enacted to reform and relax our common law rules, which prior to 2003 did not permit a third party to make decisions for a person who never had capacity. That's the person Julie was just talking about. Most of the cases that we're working with, clients never had capacity to make their own decisions or to designate a healthcare agent. And that led to some very harsh results in certain cases where people were subject to over-treatment. And this statute is a legislative response to that. And the statute permits legally authorized surrogates to make decisions to withhold or withdraw life-sustaining treatment. So then the question becomes, who is a legally authorized surrogate? And those, if you could advance the slide, Julie, those would be a court-appointed guardian is the number one on top priority. And then the statute enabled the Office for People with Developmental Disabilities to promulgate a surrogate list. So the surrogate does not have to be court-appointed. If we don't have a court-appointed guardian, there is a surrogate list, and spouse is in the top position, actively involved parent, and then adult children, siblings, and family members. Actively involved is an Opwd regulatory concept. If there is a definition, the person has to be familiar with the circumstances of the patient. Many of you may work with the Willowbrook class clients. The class members have an advocacy arm, and it's called the Consumer Advisory Board. The legislature has recognized the Consumer Advisory Board as a legally authorized surrogate. And then in those cases where there is no guardian, there's no actively involved family member, in the OPWDD system, you have the potential to use what's called the Surrogate Decision-Making Committee. That committee is formed and operates pursuant to Article 80 of the Mental Hygiene Law, and many of you, I'm sure, have worked with the SDMC program. The surrogates have certain responsibilities. Again, these are codified in the law, but number one, to advocate for efficacious treatment. And that really should be emphasized. When people think about 1750B, sometimes there's a perception that, okay, this statute only pertains to end of life, but there are pronouncements in the statute that speak to all healthcare decision-making, and the surrogate, the duty of the surrogate is to advocate for efficacious treatment. The surrogate must make based decisions on the best interests of the person when known the person's wishes. And statutory best interest considerations are on the slide for you, but they encompass the dignity and uniqueness of the person, the ability to preserve, improve, or restore health, or provide relief from suffering. So when we have a surrogate, these are the considerations that should be weighed when making healthcare decisions. The statutes also provided us with a definition of life-sustaining treatment, which we've reproduced on the slide. Life-sustaining treatment does include CPR, mechanical ventilation, and those examples are provided for you on this slide. The role of the physician. I think this audience is largely composed of physicians and medical providers. So the statute does place burdens on you. And the role of the physician is to assess capacity in the first instance. And there must be two determinations. That's something to keep in mind. There must be the opinion of an attending physician, and then there must be a concurring determination by a clinician with specific credentials approved by OPWDD, and those that clinician can include a licensed psychologist. The physician must also consider medical criteria. So there are basically 3 criteria that may apply, and the statute can be utilized if the patient has a terminal condition, and that's a definitional term, and it ties to the public health law definition. If the person is permanently unconscious, or if the person has a medical condition other than a developmental disability that's irreversible and will continue indefinitely. So those are the 3 really kind of the diagnostic criteria, but then there's a 4th criteria. The physician must opine whether the proposed treatment would impose an extraordinary burden to the individual. Now, I've had physicians tell me that physicians don't typically weigh benefits and burdens in the way that this statute operates. When we finish the presentation, if there are questions, I think this is maybe an area where we could flesh this out a little bit more. But the statutory extraordinary burden considerations are right there in front of you there, and there are 2. As you read those considerations and you're trying to apply the statute, I imagine you're thinking that this doesn't offer very much. And again, we hope to flesh this out when we're talking about our case example, but these are the statutory criteria that the legislature did codify. Julie spoke earlier about the wrinkle of artificial nutrition and hydration in public health law when we're talking about healthcare proxies, and there is a bit of a wrinkle here too. If artificial nutrition and hydration is one of the treatments that might be withdrawn or withheld, the physician must opine that either the artificial nutrition and hydration in and of itself poses an extraordinary burden, or that there is no reasonable hope of maintaining life. The statute provides for oversight, and again, the question might be, why do we need this oversight? Why do from a public policy perspective, why do we have oversight? And I would lead you back to some of those historical considerations that we discussed. And to the extent that the oversight is difficult or burdensome in and of itself, I would only offer that before we had this statute, we had the common law, and the common law didn't even permit these decisions to be made at all. So the oversight elements of the statute are something NHLS takes very seriously. And since the inception of the statute, we have tried to build relationships with providers so that these oversight activities are accomplished in a way that is not burdensome, that feels efficient and feels centered to the needs of the patient. So we have devoted resources to this oversight exercise, and we so appreciate having this audience with all of you, because this is where we really intersect, right here in this oversight. So if a patient is a resident of a facility licensed or operated by Opwd, the life-sustaining treatment decisions, the notice must be given to the facility director and NHLS. And if people do not reside in the certified setting, let's say they're residing at home with a parent or another family member, those decisions are subject to oversight by Opwd. And the oversight is exercised by providing notice. And then in practice, we've come to be using the MOLST form and the Opwd legal requirements checklist. Although these forms are not required, they've become really a very integral part of our practice, and probably yours as well. And again, we're just really breaking down these notice requirements, but I would refer you to the materials. And again, many of you may have worked with the statute, but at least 48 hours before withholding treatment, the notice must emanate, and then as soon as possible, if we're withholding. So I hope I stated that correctly, but the statute draws a distinction between withdrawing treatment and withholding treatment. And we didn't want to lose sight of the fact that the patient should be given notice of a decision unless the therapeutic exception applies. And with that, I'm going to turn it over to Julie to run through more elements of the 1750 process.
Thank you. So you heard a little bit about why, and now I'm going to talk a little bit about how, so that this is more of a a practical part of the presentation. So as Sheila talked about the notice, and the notice has it's evolved since the statute came into being. There's really, as with a lot of statutes, there's an evolution of how it operates in practice. And what we have now is we actually have forms. There is a checklist, which I'm going to show you in a little bit, which is used for notice. But before we even get to that point, there has to be a recommendation. So there's the process usually follows along this path. A physician or the other medical providers, such as a nurse at a residence, someone is making a recommendation for withdrawing or withholding life-sustaining treatment, either as a result of a progressive illness or perhaps an incident that has occurred, some type of medical incident. So first there's a recommendation from the medical team. And that is what really sort of drives the process. And there would be, I have consent, which is down under 2C, but obviously that discussion about what's recommended would also include if there is a family member, if there is a surrogate, a guardian, a family member, a friend, they should be involved in that discussion about withdrawing or withholding life-sustaining treatment. But let's start from the premise that there's been a recommendation. So what would happen next is looking at the Opwd checklist, because you really have to fit the medical recommendation, what the plan is for this individual, into the legal format. So there is a checklist. The checklist contains a number of components. One component is the capacity determination, which has to be done As was alluded to prior, there's a certain types of individuals who are determined to be appropriate to do a capacity determination. Next is a concurring opinion, so that we have two medical providers who are giving the opinion that this is what's appropriate for this individual. Then there's the consent. The consent is either from one of the surrogates on that list, which would include if the person had no family, had no guardian, had no one who had the authority to consent for them. It would include going to the surrogate decision-making committee, and then if that committee agrees this is appropriate, they would provide the consent. So that consent then goes on the checklist. And the checklist has to indicate, of course, the care that's going to be withdrawn or withheld. Now, the notice provision that Sheila spoke about is certainly an important aspect of it. Notice has to go to the patient, subject to a couple of practical exceptions. I mean, the main therapeutic exception is that the individual would have no ability to understand. If they are profoundly disabled, if they're no longer able to communicate as a result of perhaps catastrophic illness. The individual being upset by the discussion doesn't necessarily mean it meets the therapeutic exception. I mean, I'm sure physicians have a lot more experience with having these difficult conversations with individuals that we do, although we've had them as well. But some individuals are capable of understanding about what their options are, what could be avoided in terms of pain or discomfort, what their life might look like if they receive CPR or if they didn't. And I've had cases where a recommendation was made to have someone be a DNR, and then when we spoke with the individual was not only able to understand, but objected to DNR. And we're going to talk about objections in another slide or two. So the patient should be receiving notice in many cases. Again, if the person resides in a facility, then MHLS, as well as the residential provider, has to receive notice. So if they're at the hospital, the agency that provides residential services would get notice, as would the mental hygiene legal service. Usually if they're in a hospital, it's only temporary. Obviously, it's not considered their residence. Same thing if they were in a temporarily in a nursing facility, but that's not considered their residence, then that would trigger notice to MHLS and the residential provider. If they reside at home, as Sheila said, then OPWD would be given notice. And usually notice is going to consist of this checklist, as well as relevant medical records, and often a proposed or a draft MOLST. It's not a final MOLST yet because it hasn't gone through the notice provisions and the opportunity to object, but a lot of times we get a proposed MOLST or a draft MOLST. And relevant medical records are important because the people who are getting notice, which is our agency or residential provider or OPWD, sometimes you need more than a couple of lines filled out on a form to understand what the context is, to understand what's happened to the person and what are their current medical issues that are requiring or that are leading to this recommendation. So we always ask for medical records. Very often we speak with the medical providers so that we have an understanding of why this recommendation is being made. If there are no objections, then medical orders can be entered. So, I guess where's the objection slide? I'm going to go out of order for a second. So, in the legal world, the purpose of giving someone the opportunity the purpose of giving someone notice of something would be meaningless without the opportunity to object. So I think it's important to remember that anyone who is getting notice, as well as other healthcare providers who may be involved or family members who may also want to have a say in decision making, can make an objection to end-of-life care being implemented. An objection is going to suspend the healthcare decision pending some type of resolution. Sometimes it's resolved by mediation, sometimes it's resolved by negotiation or conversation, sometimes it's just a lack of information, frankly. And sometimes, but not very often, there has to be judicial review if the objections cannot otherwise be resolved. Certainly any legally authorized surrogate who's providing the consent needs to be notified of any objection. So again, in practice, objections are rare. And just so everyone there is aware, if they haven't dealt with the 1750B process, when our office, our corner of MHLS, gets materials, we try as soon as possible to indicate whether or not we have an objection. Certainly, the more dire the circumstances are, the more quickly we act to try and resolve an issue. Now I'm going to go back to where we were before. Okay, so we talked in the beginning about how we want to make sure that people are aware of where they can get resources. So there's a couple of things that are available. So in response to the COVID crisis, which resulted in many of our clients not only being hospitalized, but also in sometimes having difficulty reaching people who could provide capacity assessments or concurring opinions. Opwd instituted a 24-hour hotline to request a concurring opinion where a hospital or one of the voluntary agencies do not have access to a clinical opinion. There's the phone number. Excuse me, it's also on their website. The next thing I have here on my slide is a link to the website. So there is a healthcare decisions webpage, which is very, very informative. It talks, and I'm going to click on that for a second to demonstrate. It also gives you access to forms and quite a lot of information. The last thing on here is emails. Just yesterday, I received communication from one of the local agencies that one of the hospitals they work closely with is looking to start using emails. Emails is a website where checklists, Opwd checklists and the MOLSTs can be made accessible to anyone who has an account so that you don't have to worry about faxing. And it also sort of leads you through a progression of filling out this form, sort of a live document as opposed to using pen and paper. It has the opportunity, the availability of using digital signatures, and it's a very quick way to get information to people who are entitled to notice, such as MHLS. So I just want to show you this link here. See if it works through the magic here. Hopefully everybody can see it. So this is the Opwd website. It talks about healthcare proxies and who can witness. And then here it talks about Healthcare Decisions Act under 1750B. And it also has links to the forms, to the checklist, as well as to the MOLS, and provides information about who can witness and about the various steps, and has additional information that might be useful. So now the tricky thing is I need to get out of this and go back to my slides. So
We actually, I don't think we were able to see that, but.
Oh, you have that, you're not able to see my screen share? Okay.
We're seeing your slides, but not the link.
Okay, all right, and okay. All right, well, I apologize, but you have the link in your materials, and if you search on Opwd Healthcare Decisions, you're going to see everything that I just talked about that you could not see. Including, this is what the MOLS checklist looks like. So Opwd created this form, and I have to say it was with the involvement of MHLS, this form was created, which indicates it has all the statutory requirements. So it sort of takes you through the steps that Sheila and I have described: who can consent, what is the life-sustaining treatment that is requested to be withdrawn or withheld, what is the determination of the necessary medical criteria, and the reason for artificial nutrition hydration being withheld or withdrawn, if that is one of the recommendations. When is notice provided? It takes you through all of the statutory requirements. And this is what the MOLS form looks like if you're not familiar with it. And it goes hand in hand with the checklist. And certainly what's on the checklist, what's being requested, should match the MOLS. But the MOLS uses different language, and it has its own set of requirements. But both documents should, of course, match. So I talked about objections, and before I hand things back, this is a chart that I made really just as an illustration of some of the issues that can come up when we have a situation where there's some presumption that the person lacks capacity. So I don't think I'm going to get into it now, but I think that we can talk about coming back to it at the end of the presentation, because it's really just a sort of very quick and dirty. These are some of the paths that a situation might take for a given client that you might be working with. And, you know, I have, if you see what's, you know, I have some red boxes, and those are when the process has to stop for a number of reasons, and how they all might wind up, although again, they usually don't, where a court has to make a decision on what is the appropriate decision. So, but despite all the red on here, I think it's been our experience that in most cases, issues are resolved before you get to the point where you're dealing with an objection and a plan not being implemented, or having to resort to the legal process. So I think I am pretty much on schedule, and I'm going to turn things over to Dr. Giokas, who's going to take us through a case presentation and really give us a lot to think about the decisions and thinking that medical practitioners utilize when we are talking about end-of-life decision making.
Thank you, Julie and Sheila. So we'll start with a case. We'll then talk about some of the issues, and then return to some interaction regarding the case itself. So this was a 60-year-old resident of a developmentally disabled residence who aspirated on some pizza and suffered a cardiac arrest and was brought to the hospital. Her blood pressure and rhythm were restored after CPR. The consultants, the cardiologist, indicated that the arrhythmia was secondary to a respiratory event, was not really a primary cardiac event. And the patient is on mechanical ventilation, requires frequent suctioning, and a temporary NG feeding tube has been placed. Next slide, please. Oh, next slide.
Not seeing your slides, George.
There we go. You're not seeing my slides, Maria?
No.
Hmm.
Are you
Nope.
sharing?
Julie's doing the slides for Dr. Jocas.
Oh, okay.
Okay. So these are the patient's pre-existent diagnoses. She's on 15 outpatient medications, and as the earlier presenter mentioned, multiple psychotropic medications. The staff describe her at baseline as being very active. We purposely put in large case letters, very active, was always moving around the residence. Though she was minimally verbal, she could make her basic needs known largely by utterances and actions. She was already on a dysphagia diet, but would frequently seek out food. She was hospitalized about 1 year ago for pneumonia, but really since that time has not had rehospitalizations. And the staff indicated she actually hadn't had recurrent infection, did not have recurrent infections at the residence. And unfortunately, there were no involved family. Next slide, please. So we're now 10 days later, and unfortunately, she's not regained consciousness. Her MRI and her EEG and neurology is actively involved, show changes consistent with anoxic encephalopathy. Her brainstem reflexes are present, so she is breathing on her own, though still on a ventilator. And the neurologists say that given what they're finding both clinically at bedside, as well as what we're seeing on the MRI and multiple EEGs, that most likely she will not regain consciousness. The intensive care unit docs have had her on. Oh, can we stay at that? I'm sorry for the hand motion. She's tolerated spontaneous breathing trials, so she's still on the ventilator. but we're concerned that because of the frequent suctioning, if we extubate her, she likely will have problems with secretions. So we're at a point in the ICU now where we have to make a decision. Are we going to go ahead with a tracheostomy, or are we going to proceed with extubating her? But before we extubate her, we really need a plan as to what happens if she develops respiratory distress. Again, most likely because of the secretions issue. She's breathing, again, her brainstem is working, so she's breathing, but we're concerned about the respiratory issues. And when we talk to the, when we go back to the resident staff, they're concerned that though they'd be able to manage her if she had a gastrostomy tube, that if she needs a tracheostomy, even if she's not on a vent, that they're not going to be able to take care of her at that residence. And they were very concerned about that. Next slide now. This is a way of thinking about medical decisions, not just in the IDD population, but in the general population. And it actually comes from the surgical literature, as opposed to just the standard informed consent process of, well, you may die, you may get an infection, et cetera, et cetera. Surgeons are actually recommended to explore this and think about the two options. So we were pretty sure with either option, and as Julie and Sheila said, part of this process is a recommendation for treatment. So either way, we were sure cardiac resuscitation would not be beneficial for this person, especially in light of severe anoxic encephalopathy and no reasonable likelihood that she would regain consciousness. But this issue of, if she deteriorates after we extubate her, do we reintubate her, which means she's going to need a trach. So that's one treatment option, versus the other treatment option is, okay, go ahead and extubate her, which would be our course of action, but do not reintubate her. So those were basically the two options. We knew about DNR either way, but do we just go ahead and trach her or reintubate her and then trach her versus extubating? And so again, as part of this paradigm, which you can use not just in the IDD population, is think about what's the best case, what's the most likely case, and what's the worst case with each option, and then use that as shared decision making. And certainly there are challenges with the IDD population as to how do you discuss the best and worst case. But without going through the specifics, the best case if we reintubated the patient is that maybe she would be weaned from the vent, but she would still have the tracheostomy, but she would need a PEG. The best case is maybe the neurologist were a little bit too pessimistic and maybe she'll have a minimally awake state. Though they were saying most likely she would not wake at all. She would not return to the residence. And the best case was she might live years, but most likely because she's going to have recurrent infections due to aspiration, even with a trach, she would likely live weeks to months. Versus extubation, thinking about best and worst case, that maybe she'd get by with occasional suctioning. She would still need a PEG. Maybe she would get to that minimally awake state. She could return to the residence, but she might only live months. And again, it would be likely complicated by recurrent infections. Again, most likely she'd probably need to be on oxygen, maybe some BiPAP, which they could do at the residence, but the concern about having her go back and forth with each recurrent aspiration. And the worst case is she could die shortly after extubation at the hospital and never return to the residence. So again, I'd like you to think about that way of looking at problems in your patients. Next line, or slide. Next slide, please. So a couple of comments about palliative care. It's a philosophy of care. So this term has multiple meanings. It's a philosophy of care that works with patients, primarily looking at quality of life, both for the patient and their family. No matter what stage of life the person is in, we frequently associate palliative care with end-of-life care, but certainly individuals with serious illness, working with them to identify quality of life, what are their goals, and then supporting that, even if they're going through curative therapy or life-prolonging therapy. It's a clinical service, so I understand we have people across New York State. Here in the Capital District and across New York State, there are palliative care inpatient services at each of the hospitals. It's very rare to have a hospital without a palliative care consult team. On the outpatient basis, that's where it gets more challenging. For example, here in the Albany area, our palliative care teams have been developed over just the last few years, and we're primarily home-based palliative care teams. In other parts of the state, I understand you have more developed programs where you may have palliative care clinics, you may have palliative care clinicians embedded within cardiology clinics or oncology clinics. So again, it differs as to what is available in your state. The outpatient palliative care service provision is more variable across the state. Similarly as well in terms of long-term residencies. The skill set is what we're talking about today, is how do we apply some basic principles of palliative care across all clinicians, whether it's primary care to the general population or the IDD population that we're describing today. Next slide, please. Palliative care is frequently confused with hospice and comfort-only care. So again, palliative care, our goals are life prolongation and comfort. Patient's prognosis is not the determinative feature. Patients can have a prognosis of months to years, and the resuscitation status can be any. While hospice, really the goal is a patient has a terminal illness. We're looking at remaining time in comfort, accepting some treatments. A frequent confusing and misconception about hospice is that hospice is going to stop all of your medicines and you'll only be on Ativan and morphine. That is not correct. If you have, for example, heart failure, hospice is going to continue your beta blockers, your diuretics, because we know that if we stop those, you're going to develop more heart failure. And we want to try and extend your life to the amount that's reasonably possible. Prognosis for hospice patients is generally weeks to months. Unfortunately, sometimes it's hours to days. And resuscitation status, most hospice patients are DNR, DNI, though rarely a patient can request resuscitation and still be on hospice. Comfort-only care is really the sole goal is this patient is going to die comfortably, and we realize that they're dying within hours to days. This is the patient who's in the hospital or maybe in the residence. We're not drawing lab tests anymore. We're not doing x-rays anymore. And we're not, other medications we're not giving other than to keep the patient comfortable. And clearly to be that, you need to be a DNR, DNI. Next slide, please. So specifically end of life in the IDD population has a number of challenges. When I was doing some of this review, and I'm not an expert in the IDD population, my expertise is more in the general population and in geriatrics. It was amazing first to realize that you need to be congratulated with the excellent care you're giving people in this population. And now the life expectancy, as you can see, is now within 5 years of the general population. And because of that, we're now developing diseases that the general population shares as well. Deaths from cancer, heart disease, pulmonary disease, and dementia. There are some differences, at least in this presentation that I heard that's available on the internet, that there seems to be a higher frequency of GI malignancies, less frequency of bronchogenic breast and prostate cancer. And for some reason, Down syndrome is associated with testicular and leukemias. Common causes of death are similar in many ways to the general population because we're dealing with an older population. Cardiac respiratory deaths, sepsis, dementia, and complications of the underlying disease, unfortunately, intractable seizures. Next slide. This is a simple look at in the capital region. So that's the 7 counties around Albany County here in the Capital District. This was our hospice utilization. So we just simply used developmental disability, the ICD-9 diagnosis, and looked at what was our admission to hospice, and you can see these numbers. I'm not sure what your hospice experience is in other parts of the state. That'd be an interesting discussion. Next line or slide. And there are significant challenges. First, there's a limited evidence base on end-of-life needs in people in the IDD population. The communication barriers, and this has been alluded to in prior presentations, how that impacts our symptom assessment that can lead to diagnosis at a more advanced stage, and how it challenges how we involve patients and persons in their decision-making, as well as the patient's lack of comprehension of their illness and treatments. And it was sad, I was saddened to read this, how some patients may interpret their illness or their treatments as punishment, and how when they see maybe other individuals in their residence who have passed away, not being able to process that, and trying to also process why family members and caregivers are sad around them. Next slide. Behavior is communication. This is something I've learned in terms of evaluating patients with dementia and the indicators of distress. In many ways, as clinicians, you probably know much more about this than I do in this population. But looking at changes in behavior that, okay, there is something else going on, withdrawal from usual activities. There are some specific scales that have been mentioned in the palliative care IDD literature, the DISDAT scale, the Abbey pain scale. Be interesting to see if you've used any of these scales to help track. And I learned a new phrase today, listening to some of the other speakers, diagnostic overshadowing. But though we don't want to overlook pain as a cause of distress, there are other causes. And as mentioned by the other speakers, constipation, urinary retention, infection. Certainly we don't want to overlook pain, especially at end of life. But other symptoms or other disease states such as constipation, we should be mindful of as indicators of distress. Next slide, please. So this is from this article which we've provided, and these are some interviews of both the clinician and then some patients with mild IDD. And I suspect maybe these are some of the difficulties that you're facing as well. Difficult to know if the patient understood what we were telling him or the treatment we were giving him. Made it difficult. Are we treating the patient or are we treating the mother? And then patient, they talked to me, but they were using language that I didn't understand. They didn't have a clue what was going on, and I was very, very scared. Or they didn't want me to be worried, but if I'd known about it earlier, it wouldn't have worried me at all. Next slide, please. I'd be interested to see or to hear if any of you have used this series called Books Beyond Words. It was recommended by one of the references. I did go, it's from the UK. It's designed specifically for people who have difficulty with language. And as you can see, includes people with learning disabilities. It covers a variety of areas, including physical and mental health, abuse, trauma, grief, and bereavement. So it'd be interesting to see if any of you have used either this series of books or are there any other resources that have been helpful in communicating with people who have difficulty communicating. Next slide. So there's a model for breaking bad news, which both applies for individuals with developmental disability as well as the general population. So first ask, What have others, or what do you know about what's happening now? Repeat and clarify. In the general population as palliative care clinicians, as opposed to asking, do you have any questions, which really is not helpful, quite honestly. Most helpful is to ask the person, tell me back in your own words what you're hearing me say. And honestly, you don't want to make the person feel like they're being tested. So use language that makes it sound like you're being tested. And so I've modeled my language after others. And sometimes as a doctor, I use, doctor speak. I want to make sure I'm doing a good job communicating. Tell me back in your own words what you're hearing me say. Again, that puts sort of the onus on your communication abilities as opposed to making the patient feel like you're testing them. Check their level of understanding. You really can't move forward unless they have an understanding of what's going on, and help the patient express feelings. It's okay to simply say, I can hear this is upsetting. If your sense of communication with the patient, and so much in patient communication is nonverbal cues, whether in the general population or the IDD population, I can see this makes you feel you're upset. I can see you feel sad about this. Many people would feel angry hearing this information. So it's all right to make those short, they're called empathic statements, which if it helps the patient with their emotions, then you can go ahead and process cognitive information. But when the person's all upset, when we're all upset, we don't process information very well. Next slide. Another general paradigm for any treatment, whether in the general or the IDD population, of determining whether to proceed with a treatment is this sense of benefit, effectiveness, and burden. So the benefit is what the patient is hoping the treatment will achieve. And again, we really have to remember that when we're deciding on a treatment, what is the patient looking for as a result? And especially our challenge is, how do we determine that in this population? The effectiveness is not the physiologic effectiveness. Is the treatment going to meet what they're hoping the treatment's going to do? If I do a knee replacement, they're going to be able to run the marathon. Or if I put a feeding tube in, are they going to be able to return to the activities that they so want to return to? And effectiveness is really something that as clinicians, we identify. Is that going to meet that benefit? And the burden is a combination of both the clinician and the patient. Next slide. So again, benefits. This has been from some interviews of individuals with mild IDD. You can see some of the things: being involved in their care, remaining occupied, certainly being comfortable, and having family and friends around. So is the treatment that we're recommending going to meet some of those benefits, those goals? Next slide. Burdens, and especially in this population, how will they understand it? Will they comply with the treatments? Are we going to need restraints or sedation? Will the treatments cause undue pain or suffering or fear, taking them out of a familiar residence? Again, many times we think of burdens as physiologic side effects: nausea, rash, diarrhea. Think of some of these others as burdens. And how is their quality of life going to be affected? Next slide, please. So briefly, and I'm running a little bit over time, I apologize. We are not good prognosticators as clinicians in the general and especially the IDD population. We tend to overestimate prognosis. Cancer in general is more predictable than cardiac, COPD, or pulmonary diseases. If we look at the IDD population, specifically new dysphagia, when it's due to progressive neurodegeneration, especially advancing dementia, complicating IDD, and now with dysphagia and recurrent aspiration is a bad prognostic sign. And then recurrent hospitalizations, especially, and I think Dr. Kansas said, same old hospitalization, one after another pneumonia is a bad prognostic sign. Weight loss in the general population, frailty, progressive frailty is a significant prognostic indicator. How do you assess frailty in this population that may already have limited ambulation due to orthopedic difficulties? Prognostic tools, there's one we use called the Charlson Comorbidity Index, but unfortunately it's not been validated in IDD patients. And the surprise question is actually very effective. Asking yourself, would I be surprised if my patient dies within the next year? Very simple question, but that should then be a trigger that maybe we need to be discussing these issues. Next slide. So communicating prognosis, both for the general and the IDD population, first ask permission. Not all patients want to know this information. Then explore what they're thinking about, what others have told them. Some people want to talk about time. Other people don't want to talk about time, but want to talk about what does my future look like? If they express a preference regarding time, is there a date important to them? Is there a birth date, an anniversary, something that's important to them? Are they statistics? If you're going to use time-based, again, please use these phrases. This is not my recommendation. These are general palliative recommendations. Hours to days, days to weeks, weeks to months, months to years. Try to use those phrases if possible. Next slide. Okay. I believe at this point, we wanted to open it up to comments as well as specifically about the case or any other issues.
We do have a few comments and questions in the chat box. So from Sheila Thurman, she states, on occasion, I have difficulty with a hospital not understanding the MOLST process. Should we be sending the hospital the link or hotline number or something else? COVID and visitation at times can complicate this process, as at times we have been denied entry into the hospital due to COVID, therefore making communicating with the hospital practitioners difficult. I can speak to that briefly, George, although I'm very lucky to have Dr. Jocas in my neck of the woods. We have worked really hard in the time that I've been with the center to build contacts in our local hospitals. I have a social worker at St. Peter's who knows my name, has my cell phone number. You know, at Albany Med, we've had meetings with their ethics board. We've talked a lot with them. And then Dr. Jocas is at our other local hospital center. So, you know, it took a lot of time and education, my own education included, because was certainly coming from private practice. This was a new world for me 7 years ago. But I think finding someone, whether it's the ICU social worker or the ethics committee, can be really helpful, particularly if you have a person in your organization who can be the contact point.
Maria, so Maria and I haven't prepared this answer, but it's actually, I was thinking earlier as one of the points I wanted to bring up is try to identify, and this is again, different practices at different hospitals. Some hospitals at Ellis, where I work, for example, these cases go through the palliative care team. At other hospitals, and here just in the Capital District area, as Maria said, at St. Peter's Hospital, it tends to go through the ethics committee. And at other hospitals, it might be the social worker in the ICU. So find out for the hospital that you work with, who is involved in these decisions. Is it a palliative care team? Is it the ethics committee? Is it a social worker? And then again, develop those contacts. And they need help. Believe me, they should welcome your help. They should welcome your help because they're looking, they frequently are at a loss as well.
I think the other thing is, you know, with the hospitalist system sort of entrenched now and a different person is on every day, you may find that one person knows a lot and the next shift doesn't know anything. So it does require a lot of effort, I think, on as the patient's advocate, to make sure that as many people as possible know that you're interested, that you're involved, and that you have something to contribute. It's challenging, to say the least. The next comment is from Kelly Nellis. She wrote, unfortunately, most of our physicians do not see any diagnosis of IDD as equating to any quality of life. So we are quick to want end of life order put in place. So they are quick to want end of life order put in place. I think this goes back to the perception of the unfortunate person. And that also, I think, is about education. I think that noontime presentation that we had, you know, should be in every single medical school. I think that was a beautiful thing, and needs to be part of our, and I'm talking about healthcare providers' education. George, would you like to? I don't mean to steal your thunder. Sorry.
Oh, and I saw parts of that noontime presentation, and it was very powerful, very powerful. So how do we connect the dots in terms of so do you have grand rounds, or we used to have grand rounds if we're talking about hospital-based programs? Do you have grand rounds at your hospital where you could go to your hospital and bring up some of these issues? Hospitalists generally have meetings every month, so ask if you could be part of the hospitalist meeting or the case manager's meeting. So absolutely try to make those connections. And unfortunately, COVID has made us more disconnected.
I think for any of us who are clinical instructors at medical schools, I think this is an opportunity to get that idea put forward. It's not a part of the general curriculum everywhere. And I appreciate the efforts of everyone who's trying to make it so. So I think we have a lot of work to do there. Are there any other questions about the process, about the legality of the whole procedure and forwarding a most? Julie and Sheila, is there anything you'd like to add?
Dr. Kansas, I just wanted to add for the audience that we do expect the Department of Health to be issuing a new MOST form. We might see that in December or in January 2022. But I think I've seen a draft of the new form, and I think it's going to be beneficial. There's been considerable conversation with stakeholders, including EMS, so the emergency medical service physicians, people working with ambulance companies, emergency room physicians have had input in the form. And those medical orders, for example, that we see DNR and DNI, the DNI order will be moved up to the first part of the form. Right now it's on the second page, but there'll be some adjustments. So that will be something new that will be coming soon. There was a conversation and a proposal to create a separate MOLST form for people with intellectual disabilities. And the Office for People with Developmental Disabilities, OPWD, had suggested that last in 2019, just before COVID, before there was a massive shutdown we all experienced. There was conversation about creating a separate MOLST form, but it was it quickly dissipated. There was a thought that we should not have a separate form for this population, that it would be further discriminatory, for example, to have a separate MOLST form for people with IDD. So we will not see that, but we will likely see a new MOLST form in the future.
So I'm putting the, I'm sorry that people couldn't see the live link before, but I just put in the chat the link for the OPWD website. I have, when I've spoken to providers, either people who work in the facilities or medical providers, I have encouraged people to look at the website, especially if I get a call from someone at a hospital and they don't really know where to start. They're not really sure. There's someone, maybe they have someone making decisions for them, but they just don't know what the whole process is going to be. Rather than first get acquainted with that when there's a crisis happening, it's good to sort of be proactive and try to figure it all out. So I do refer people to the OPWD website. Also, people could call MHLS in your coverage area and ask questions and talk to the director of medical services for a given agency. Should be well versed in these type of issues. I think, as Dr. Devine had said, forming partnerships with the various individuals at the local hospitals is certainly very important. I know that's something that we try to do. We have a couple of minutes, and if there's, there aren't any other questions, I can talk a little bit about the flow chart here. So my chart starts with the premise that it's someone who people feel do not have capacity to make an end of life decision. So the first question is that you might ask is there a healthcare proxy with an available agent? So you contact, let's say the person lives in a community residence. Those are most of the cases we have. And you might reach out to them and do they have a healthcare proxy in their grab and go book? Can someone look through their records? MHLS, at least in my neck of the woods, and the third department, Albany, and some of the other offices, we've been asked to comment on the validity of healthcare proxies over the years, and so as a result, we keep them. We have digital copies of them. So sometimes I'll get a call from a hospital, and they'll say, "Do you know if this person has a healthcare proxy? I can't reach the nurse at the house," or they're new and they're not sure where the records would be. And I can look through our records and I can determine that they do have a healthcare proxy. It's properly witnessed. We believe it was valid, and I can send you a copy if you like. So, we've done that, many times. So the first thing you might want to do is find out if there's a healthcare proxy with an available agent. The agent is alive, willing, and able to make a decision. So if there is something that is proposed, a decision that's proposed for the agent to make, and they're talking to the patient about it, because as of course we should, they're hopefully using some of the tips that Dr. Giokas talks about, and the patient says, well, no, I don't agree with that. Any individual who has a right to disagree with something that your agent wants to do, and if you disagree, then there has to be further steps to determine whether the person has capacity. It often might result in some type of legal determination. So if I have a healthcare proxy and my healthcare agent says, this is what I think should happen with Julie's medical care, and I say, wait a second, I disagree, I don't want you to be my agent anymore. Under the public health law, that's something that would have to be explored legally. But let's say that's not the case. The patient is not objecting, maybe they don't have the ability to communicate. So the agent can make the decision. If the person has an intellectual or developmental disability, there's a different checklist. It would not be the OPWD checklist that we talked about. It's Department of Health checklist number 2. It can be found on the New York State Department of Health website. And that is, it's a different type of checklist. It's not sort of something that has to be completed and then provided to people. It's more of, have you gone through the proper steps? Person has a healthcare proxy, they're intellectually disabled. Do they lack capacity right now to make a decision? And if so, then it might tell you who you have to give notice to. If a decision is being made by a healthcare agent, even if the person resides in a facility, you do not have to notice MHLS or the residential agency, because the person's already left their decision making in somebody else's hands. We have to assume that that person is going to do the right thing under the public health law, and so we don't have to receive notice. A lot of times people give us notice anyway, and unless we see some giant red flag, we say thank you for the notice, and we don't really do anything beyond that. Let's say there is no healthcare proxy or there is no available agent. Well, is there an appropriate surrogate under 1750B? Yes, let's say there's a sister who's available, who's involved, and is willing and able to make decisions. Then you would go through the OPWD checklist. Is the patient, do they reside in a facility? It has a little asterisk there because again, we're talking about a specific type of facility. Let's say they live in a community residence operated by the DDS, one of the local DDSOs, and they're temporarily in a nursing home because they had a fall and they were recuperating. They usually would still be considered a resident of the community residence if their rehab was only considered temporary. So yes, they're considered a resident in a facility. And again, if you have questions on this, it's better to ask because it can get complicated. If that's the case, then notice, including checklist, medical records, other information, would go to MHLS and the residential agency that provides them with their residential services. If there's an objection, the plan cannot be implemented. Maybe there are other steps. Maybe there's a question of a lack of information. Maybe the people receiving notice don't understand what's being sought. Maybe the forms aren't filled out completely, but there's some objection that will need to be resolved. If the patient is not in a facility, the example Sheila gave, someone who is intellectually disabled, they reside at home with their parents, for example, they would still need to do the OPWD checklist, but they would only give notice to the local OPWD office, usually to their medical director, who sometimes even serves as giving a current opinion. And again, if there's an objection, maybe there's another family member who has an objection and they're entitled to object, then the plan would not be implemented and you would have to try to find a way to resolve the objection. If you can't, then the court is always there to try and resolve issues. If there's no 1750B surrogate, there's no family, there's no guardian, you go through that whole list and the only entity available is the surrogate decision-making committee. You can ask for an expedited hearing of the case. We've heard cases on 1 day's notice. We've heard cases on same-day notice, frankly. It would go to the surrogate decision-making committee. If the committee provide consent, they're the person who provides consent on the checklist. You still would do the checklist. Sometimes people do the checklist at the same time that they complete the packet for SDMC because it's easier. And then the notice of the checklist would go to MHLS and the residential agency. MHLS was probably there at the SDM hearing, so they're familiar with the case, but you still need to do the checklist. And then at some point, a proposed or completed MOLST would be provided. If surrogate decision-making committee does not consent, I mean, that's happened on occasion, or maybe there's been an objection to the decision or to holding the hearing at all, then you would have to stop and try to figure out how to resolve the issue. But those are just an example of some of the things that might come up. And this is sort of just a very loose guide, because even within those examples, there's all sorts of other things that could happen factually and legally. But I wanted to present that maybe as just a way of thinking about some of these issues.
Thank you. Thank you very much. That was an excellent presentation.
Maria,
yeah.
I was looking at the comments and wanted to go back to the comment by Sheila, and it seems also with Kelly, Kelly's comment as well. And I'd encourage, if you have a patient in the hospital who you feel the hospital staff is not either understanding the MOLS process or really not caring for that individual as they should be cared for, I really would encourage you to reach out to the ethics committee. And not every hospital in New York State has to have an ethics committee. The ethics committee in most hospitals is not looked at as the ethics police. So it's not like a police action, you're calling them on them. They really are a resource for the clinicians in the hospital, most importantly, the patients, and involved families. And in most ethics committees, anyone can involve the ethics committee. So I really would encourage them as opening the avenue of communication that it sounds like you're being shut out from. So please consider that.
Thank you. We are right on time. We have 5 minutes before the next presentation at 2:50, which is skin integrity and pressure injuries. It's a very common and concerning issue in our population. So we'll see you back in 5.
Thank you, everybody.
Thank you.